there could be potential legal ramifications against those.
Sure, they could be kicked off the program altogether.
Right.
You can't utilize it. They could just be fined. They could. You don't know what the penalty may be. So the point is just comply.
Yeah. Hello, everybody, and welcome to this episode of Property Management Law Solutions podcast and webinar. We're going to combine these two today. This is our last webinar and podcast for the year 2025. Can you believe it, Mark?
Not at all.
By the way, for those who can't see, Mark Nicklow is in this recording room with me, and he's one of our associate attorneys at Property Management Law Solutions. And so, Mark, we're going to talk about what we plan to do, which is lessons from 2025.
Sounds good. It's been a long year and a lot of lessons learned.
A lot of lessons learned. I think it's been a long year, but in some ways it's been short too. As they say, time flies. So we have a few topics that Mark and I thought would be really good to just share with our listeners about things that we have learned and things that we've encountered quite a bit in 2025 to help the landlords and property managers out there just kind of get a sense about what we've experienced and some of those lessons that we think are good to know. So let's just kick off. I think three, I say three, maybe four.
Sure.
Depending on the time here. First is, and we talked about mold already in our previous episode, but we're just going to kind of hit that. But mold is such a big topic that we think is important just to highlight. The other is AI and how that's changed the landscape of what we do.
Yeah, it kind of affects the mold situation as well.
It does.
It allows tenants, but we'll get into that.
No, it affects everything, really.
Yeah.
The other, of course, is the lawsuit that you may be familiar with already that was filed in Colorado in federal court against Greystar. You know, probably the largest property management company in America. They entered into a consent judgment or a settlement agreement.
Right.
So some of the things that came out of that case are important for people to understand. And then we did have one more, Mark, and I'm trying to think of what it is, but it's leaving my mind. Do you remember?
I don't, but it may pop back up. We may have time for it.
Yeah.
If not, we can always talk about that letter we reviewed yesterday.
Oh, yeah. That's right. The letter from HUD. That's right. That's another good one, which is actually pretty big deal.
Yeah.
Let's jump into this. I think first of all, let's just start with just a highlight of mold.
Sure.
Okay. So again, last episode, we really had over an hour conversation between you and me, and of course the audience that was there had some questions. But share from Mark, from your perspective, what we've seen this year, kind of how you think we should just leave our audience with the big lesson of 2025 with regard to mold.
Sure. Yeah. So what I've seen this year, and I'm sure you have as well, and probably many of you listening, is just an increase in mold claims. We talked about it last week. What's the standard? Where are we at? We review the Department of Health's website, and they say, well, there's mold everywhere.
Yeah.
Okay. So do most leases. Most mold addendums say the same thing. Hey, there's mold everywhere. But what tenants are doing is they're trying to get out of their lease by claiming mold.
Withholding rent.
Or withholding rent.
Yeah.
And maybe sometimes it's legitimate and sometimes it's not. And you just have to do your due diligence on that front. We talked about your mold addendum, which is great, and I do recommend it to everybody.
Yeah.
7 pages of mold addendum alone is enough to cover you. And that's really what you're looking for, is how do I protect myself? Where's the risk management here? And that's kind of what we want to do, is do your due diligence, make sure that you investigate every claim, at least by inspecting the unit where they claim there's mold, and then see what happens.
Yeah. Well, just having the process and procedure in place in writing and signed by the tenant, it goes a long way.
Yeah.
And it's something that it's necessary. It just really is necessary now. I mean, I don't have my like a report showing us this, but just from the experience of our law firm, we get them at least maybe once a week, maybe once every 2 weeks.
Yeah. Oh, definitely.
A mold case.
Yeah. Well, a property manager reaches out and says, hey, this is a situation. Sometimes it's not even a property manager. Sometimes I get a demand letter
Yeah.
from an attorney who's already taken up the case.
Right.
This tenant was in the unit, and they've been seriously harmed.
Yeah.
Their medical
Yeah. Yeah.
and mental some
Right.
because they had to go through this tragic situation with mold. So it's really just about, hey, do your due diligence, manage your risks accordingly, create processes, put those in place so that your property managers know, so your maintenance supervisors know, hey, this is what we need to do.
It's like I thought when you were talking, it's like mold is a monster. It's just roaming the streets.
Yeah.
Who is it going to attack next? And that's what it feels like, really, in a way.
That's what the personal injury firms would have you believe, for sure. And sometimes the tenants, which kind of, it's a good segue into the next topic when we get to it. But it's what AI will do. Yeah. They're gonna paint this narrative that says, they suffered through this horrible situation, this horrible circumstance, and they couldn't leave. They couldn't leave the apartment.
Yeah.
And they left their children in this mold-infested unit.
Yeah.
And it caused all this harm. And now they need to either not pay rent, they need to sue you for damages, or any other circumstance that they decide.
It can just get out of hand. It's just like it spins out of control.
Yeah.
And a lot of landlords, they simply don't know what to do. They don't know steps to take, who's right, who's wrong, what are the risks, all those things. And so really, I mean, it's like a lot of what landlording is all about. You really need the agreement to provide for the steps.
Yes.
I mean, that's kind of the lesson.
Sure.
Right? And that does kind of lead us into the next big one, which is AI. AI has transformed, revolutionized, and completely changed the way people relate to each other, get their information, present information. And while it's a great tool, I think at the same time, it's created somewhat of a chaotic situation.
Yes, I completely agree. What it's done, I mean, I don't want to say it's leveled the playing field because it really hasn't. But what it's done is it's given the I guess the image for tenants especially that, hey, now we're equal.
Right.
I can make arguments just as well as you can. So what I'm seeing from a litigation standpoint is, one, we just talked about it. We're seeing increased lawsuits against the landlord in personal injury cases or discrimination cases. We have the big one down in South Florida on that. But also when we file these evictions, we typically they would go uncontested, but in more recent circumstances, you're getting AI answers.
Yeah.
AI is telling them, hey, you're right, tenant. You shouldn't have had to pay the rent because of this circumstance or because of that circumstance, or the lease violation that they're accusing you of is improper, and it allows them and it affords them to file an answer, which creates more work for the attorneys, which I don't have a problem doing because I'm going to win sale regardless.
Well, yeah.
It just costs the landlord more money.
It does.
In fighting these cases.
It's amazing because AI can take whatever you've put in and it'll spit out sort of what it knows you're looking for.
Yeah.
And people who aren't trained in the law and how to be a lawyer can put information in that it just basically spits out a plethora of maybe related subjects or whatever. And some of it could be relevant in the sense that, okay, like if we're dealing with a non-payment of rent case, it may suggest some things, but then there's other things that it just spits out. It's like, this is not relevant at all.
Correct.
And the problem is from our standpoint and from the court standpoint too, is that now we're dealing with all kinds of legal theories that are presented that are not based in fact, or they're misapplied. And so now we've got to deal with all this stuff because they file it So now we got to deal with it.
Uh-huh.
It could be motions to dismiss, a motion for summary judgment. It could be motion for judgment on the pleadings.
Yes.
But ultimately, depending on the court you're in front of, some courts may say, okay, you've got all these allegations in your answer or in your affirmative defenses. Okay, we're proceeding. Or, hey, we're going to hold a hearing on these things, right? And it does. It puts a lot more work on us, which for the landlords means more money.
Yeah.
Also, it's just there's more potential hurdles to get to the end result.
Right. And a lot of the time, these hurdles, as you just mentioned, if we're filing motion to dismiss, a motion for summary judgment, a motion for judgment on pleadings, it's because AI is presenting arguments that aren't real.
Yeah.
One of my favorite letters was I received a demand from a client, or not a demand, but a 7-day notice or in termination of tenancy based on the 83.959 or something. I forget what the exact statute she cited. The violence against women section of the statute, or domestic violence section of the statute.
I remember this. By the way,
the problem with that is there's no domestic violence statute. There's part of 83.
Right.
There are other avenues for that, but in this particular situation, AI is citing to a section of the statute that had nothing to do with what she was alleging it did, or what AI alleged.
We see that all the time.
And it just creates more of a burden on the landlord, because they send it to me, of course, and I have to respond, or I have to do research and inform the client, the landlord, that this is incorrect. Completely.
Well, it's here to stay. I mean, AI is here to stay. So really the lesson for landlords is, because this is going to come to you even before maybe it comes to an attorney, because you're dealing with the tenant face-to-face or phone-to-phone or email-to-email, and you're going to be getting these things in your inbox or on a call, and you may not know how to respond. You may look at what they're presenting and saying, oh, crap, maybe they have a point, or maybe they're right. I don't know. So I think from our standpoint, the real advice or lesson is landlords need to have an attorney who specializes in their business so that they can call and say, this is what's going on. What do I do?
And we can advise. We can advise. I think it's right here, actually.
This legal advice. Right there. So just be, that's coming. And AI is going to become more and more sophisticated.
Yes.
It is a great tool. Like I've said before, Mark, we do use AI in this office in a couple of different ways. But, one of them is through the Lexis program that we pay a lot of money for every month, which is a closed AI system. It references only the content within that website, which is all very reliable, which is great for us.
Right.
ChatGPT and those kinds are helpful. As I've said, they're helpful for us and for me. It could be a writing assistant. Like, here's what I know I wanted to say. Here's what I want to do. We check it, make sure it's correct. But it's like having an assistant in your office to write things. It's great.
Sure.
It can help flesh ideas out. And then you weed through and you say crap or good or whatever, right? So
all the time.
So it is a great tool, but again, it's just going to impose more demand on landlords to either, one, know what they're doing, or two, have an attorney who knows what they're doing.
Correct.
Okay. All right, let's move to the next one, which is a big topic, which is the HUD letter that you mentioned. And you brought it to my attention. I wasn't actually aware of it. So tell the listeners a little bit about that one.
So one of our clients received a letter from HUD. I think it was middle of last month or late last month, just essentially from Trump is the way they're presenting it, is, hey, we're taking a stricter approach to those owners and housing authorities that enroll tenants in HUD, or that have tenants who participate in HUD in any of those programs. And what the letter essentially says is, hey, stricter compliance in your initial investigation background check. These are non-starters. They give you a list of non-starters, which includes any sort of history with drug use, or not any history with drug use, but to a certain extent, any alcohol abuse, if you've been arrested for any sort of violent activity. These are non-starters. You can't allow these folks.
Don't admit them into your program.
into the program, into the HUD program. They can't utilize it, but it's also strict enforcement on the other side, and it's a one-strike rule. That's what they emphasize. In the previous administration, things were a little bit more lenient, and we're going to see that. It's going to ebb and flow throughout time and throughout history, based on who's in charge.
Who's in charge?
And currently, we have a conservative president in the White House, and so that's what we're seeing. We're seeing a more strict application of the rules.
Yeah, and I've gotten this question so many times in the past 20 years about selection criteria for residents. What's a fair housing violation or not? And one of the common sort of questions about that whole question is, how far does disparate impact go as a legal theory? Well, the legal theory has been recognized by courts, and simply to say that when your policy, while it may be neutral on its face, could have an impact that disparages or is disparate against protected classes.
Correct.
Right? So, like, for example, criminal convictions may affect a minority class more so than a non or a majority class. And so that's the idea. And so with this letter, it kind of sort of takes the wind out of that sail as it relates to certain criminal activity.
Correct. Yeah. What they're saying is it's not about any sort of protected class. It's about your personal history.
Yeah.
It's putting it down to the minutia as opposed to a broad perspective, right? We're saying we acknowledge that some minority groups may have a greater percentage of
convictions.
Yeah. But we can't allow this individual who has a history with violence or with drug or with alcohol abuse to utilize these programs because it's just going to further that abuse.
Right.
It's just going to further that. I think that's the idea. But in addition to that, to the strict compliance, it also the letter provided a broader discretion for landlords, which I thought was interesting.
Yeah,
because it wasn't specific. It pretty much said broad discretion.
Yeah.
In determining who you're going to allow in.
Yeah. Well, and so the lesson I think here is that politics matter. Yeah. They do affect housing. Just like the case in Colorado against Greystar, which is the next topic, Mark. But politics drive certain things, and so in this particular instance with HUD, it seems that because of this letter, landlords who participate in HUD or public housing authorities have a directive now, and it's more strict as who they can admit into their properties, and if they violate that, there could be potential legal ramifications against those.
Sure, they could be kicked off the program altogether.
Right.
You can't utilize it. They could just be fined. They could. You don't know what the penalty may be. So the point is just comply.
Yeah. Yeah, and again, talk to your attorney about, hey, here's our resident selection criteria. Given the new directives, how should we adjust, if any?
Yeah.
So
absolutely,
that's a good one. Moving into then Greystar. So Greystar, as I'm sure some people listening know, were sued by the Federal Trade Commission and state of Colorado to include a number of essentially violations of federal law. Actually, I'm not sure if federal law was included, but maybe it was. But certainly state law under the Deceptive Practices Act, or the prohibition on deceptive practices in that state.
Yeah.
A lot of people were paying attention to it because Greystar is such a large company. I think maybe the largest property management company in America. And they're in the news a lot.
Yeah.
And so this lawsuit alleged a variety of things, including they were using hidden fees. They weren't disclosing those to the tenants or to the applicants who were looking at the property for rent, the way they handle security deposits, and so on and so forth. So give the listeners, Mark, sort of your take of not so much the merit of those arguments, but rather the kind of risks that landlords face now today.
Yeah, no, absolutely. And what I'll say is typically with attorneys like this in mass torts, they're going to start with the biggest bear, and they're going to move down. And that's the risk here. Is Greystar was accused of all these. We talked about the hidden fees for quite a bit before this podcast here, before this webinar. They were listing the rent as one amount, and they were then adding in all these fees on page 30 or an addendum to the lease, which is common practice in this industry.
Right.
But what the lawsuit says is that's wrong.
Yeah.
You're taking these uneducated people or these uninformed people, and you're having them sign up for a lease, and then what they thought was $1,000 rent turns into $1,500 rent per month. And the risk that you face with that is just that you might get sued if you don't properly disclose everything. If you include a clause in your lease that says we can just keep your security deposit without notice, you can't do that.
Yeah. Not in Florida.
No, make sure you're following the rules. It's risk management.
It's funny because when I started to specialize in this area, this is back 2006, some of the things in that lawsuit I have been talking about for years. And one of them, the hidden fees, was a big one because you always sort of saw on the political front the tenant advocates who talked about this a lot.
Right.
Hidden fees. And so years ago, I said, okay, let's try to resolve that issue altogether. Because here's what we're going to do. We're on the front page of the lease. We're going to say, here's your base rent, and here's what the monthly recurring charges are for rent. So it's all disclosed on one page at the beginning, which I thought was a great idea.
It is a great.
It helps the landlord just know what they have going on. When you hire staff, you want to make sure that they know, here's what we have, here's the charges, and they're collecting the amount, that amount that they're charging. So it's easier actually from an administrative standpoint. So it made sense.
Yeah.
Same thing with the security deposit. Because I don't know why this is the case, but so many people still, even though our statute regarding security deposits in Florida has been the same since I was probably in elementary school.
Right.
Like 30 plus years ago.
Yeah.
And yet they're still operating on this idea that you can just forfeit someone's deposit.
Yeah.
And there's been so many court cases saying you can't do that. The statute is clear. Yeah. And yet here we have the largest company still using those practices.
Yes, practicing their way. Why not?
Why? Why? I don't understand that. I can understand the hidden fees sort of thing. Is like, well, this is just how our lease is, or we're truly advertising base rent, and we're disclosing the fact that there could be additional fees. We have a hyperlink. You click on the hyperlink, it discloses those fees. What's the problem? Okay, I get that. Mm-hmm. What I don't understand is how you still have professional property management companies that are clearly just not following the statute.
Well, the answer is money. They see an avenue for money, and to restrict additional administrative costs. Okay, we don't want to have to go out and file a lawsuit every time a security deposit claim is disputed, right? So it's just easier. Let me just keep it.
Yeah, let me disclose this, by the way, because I don't know actually. I haven't seen what Greystar actually does in that regard.
Yeah.
So I'm not here judging that if they did it right or wrong, but regardless of Greystar.
But we know that this happens in the industry, not necessarily with Greystar, but with other companies, with other property management companies, other landlords. We see it throughout the industry. Yeah. I have clients who tell me all the time, can I just keep the security deposit because the tenant moved out early?
Right.
No, you still have to send the
notice.
The notice. Yeah. It's mandatory. It's statutory, and that's risk management. You want to abide by the law, not industry standard.
Yeah.
Industry standard does not mean correct.
That's so true. No, I mean, yeah. So
we see it all the time, and it's the fees too. It's the same thing. These hidden fees. It's almost the way the lawsuit portrayed it is false advertising, right? You're putting up on your billboard, come rent at Joe Schmo's apartments for $1,000 a month.
Right.
And they get in there and they sign this lease, and on page 20 or 30 of the lease is the addendum, which you have the prospective tenant sign.
Yeah.
But it says a list of fees that are all mandatory.
Yeah.
These aren't optional. These are mandatory fees. So now the rent, which was advertised $1,000, now becomes $1,200.
Well, this year there were other companies that various attorney general offices sued as well. I mean, Greystar's not the only one. There were others.
Yeah.
Similar sort of thing. Similar issues. There's one in Florida. I wrote an article about it where similar thing, a similar regarding treatment of security deposits, as well as the Service Member Civil Relief Act. It's a mouthful to say.
Yeah.
Treating security deposits or fees or rent concessions for military tenants who get orders and leave, right?
Right.
And all that boils down to, I think, the lesson I see here is that, first of all, if you're an executive in a corporation that owns or manages rental property, please get an attorney who's not just corporate counsel, who's not just someone who might litigate issues for you whenever you get sued. You need someone who knows your business inside and out, who knows the issues, who can look at your business operations and say, here's some risk here, here's some risk here, here's how we can mitigate, here's how we can eliminate risk.
Yeah.
And it's reflected in certain documents that drive their business, their operations.
Yeah.
Like, you need that.
Yeah.
Why risk these things for potentially not even just the settlement aspect, but just the nuisance value of having to go through these lawsuits?
You're absolutely right. And that's something that we talk about all the time. It's something that if you ever call up here, the first question I ask you guys is, what do you want? What do you want to happen? How do you foresee this going? And then you tell me, and then we advise on the risk. We are very knowledgeable about the statutes. We are very knowledgeable about case law and industry standard here. Yeah. And we want to help you find an avenue to your desired goal. But sometimes there's a lot of risk that goes into that.
Yeah.
And at least if you go to outside counsel as opposed to inside, you're going to get a legitimate assessment of your issue.
Yeah.
So
yeah.
I think it's very important to handle it that way.
Yeah, absolutely. All right, so I wanted to at least keep this somewhat brief as our last chance to do this in 2025. I thought it's been a great year. Here at Property Management Law Solutions, we continue to grow, continue to help more and more landlords and property management companies throughout the state of Florida. And I've had a great time. It's great having Mark join the team. He's doing an excellent job, and people love him. I'm sure you do as well, just looking at him from the camera. So it's been really good. What would you say, Mark, for your the final comments of the year?
Call us.
Yeah.
And I mean that in the sense of when an issue arises, call us.
It's a relationship.
Yeah. Yeah, of course. I'll go have a beer with you. I don't know.
You definitely will.
I'm not. We can be friends or we can be professional.
Yeah.
I take the approach either way. And but what's important is whenever a situation arises that could be somewhat legal in a sense, give us a call.
Yeah. No, it's great.
Yeah.
Well, on that note, I've had some clients that started using my services back when I was a solo practitioner, and they're still with me.
Yeah.
And that was 20 years ago, and I love having that long-term relationship with clients. I really know what they're doing. I know their business. I know what documents they're using.
Yeah.
They come to me on a routine basis to say, hey, can I update this, or should I update this? And the answer is almost always, yeah, we can update it.
Of course.
There's always something to update, but to see that those relationships flourish like that, to me, brings me a lot of joy. So I know you feel the same way, Mark.
Absolutely.
All right, y'all. Well, this is going to end this webinar / podcast, and we're glad that you joined us, and we wish you a very happy holiday season. Merry Christmas to all out there, and we'll talk to you in 2026 next year. Have a good one.